Hello, friends and clients. I am Jennifer Walker-Gate, board certified immigration attorney with JLW Immigration Law Group out of Austin, Texas. I am here today in this video to share with you about the steps for petitioning for a fiance, thing that we hear about from a lot of clients. We've helped a lot of clients petition for their fiancés from other countries and get all the way to a green card, and then ultimately talk about citizenship for your fiance. So that's what we're going to be sharing about today in today's video, is basically the steps that you need to be ready to follow in order to successfully get your fiance into the United States and across that finish line to getting a green card and on the path to citizenship. Before I jump into the substance of today's video, I want to take a moment and please ask you to subscribe. Subscribe to our channel. We are trying to get to 10,000 subscribers this year. We're a little over halfway there. Really excited. We want you to be sure and share the video if you like it, if you find it helpful. Share it. Leave us comments. We do respond to comments and questions that are left on the page. And subscribe to our channel. It helps us get the word out. We want to make sure all immigrants in the U.S. and everybody who loves someone from abroad is able to bring them to be securely with them. Families united securely and stably in the U.S. That is what we are all about at JLW Immigration Law Group. So please help us get the word out, help us share our YouTube channel, and we appreciate it so much. So let's talk about what it takes to get your fiance, the country that they're in right now, to the United States, to join you in the United States, and then all the way through to a secure and stable long-term permanent resident status on the way to citizenship. All right, the step one is when you are sure that you are ready to get married as soon as that person gets to the US or within 90 days of their entry, then you file what's called the Form I-129F, petition for fiance. All these forms and the immigration law still use the word alien a lot. So you'll see that probably on the title of this form. I do not like it, so I always leave it off. I find it to be not only offensive, but also very inaccurate and outdated. So I don't use that word. But when you are ready to petition for your beloved fiance, you file Form I-129F. Now, it is really important to pay attention to the required evidence for this form. If you want your case to go as quickly and as smoothly as possible, you need to make sure that your I-129F has all the proper evidence attached. That will include a written statement from both you and your fiance, indicating and attesting to the fact that you intend to marry within 90 days of their entry to the US. You also have to show evidence of that. That could be, reservations at a restaurant to celebrate, to have a celebratory wedding dinner. It could be reservations at a wedding venue. It could be wedding invitations. If you plan to have a very simple wedding, then you're going to want to at least include, a letter, a sworn statement from a best friend or a witness, someone who is going to bear witness to your wedding. Even if you would hope to have a very private personal wedding one-on-one with your fiance and whoever's performing the ceremony, then have the person performing the ceremony provide a sworn statement to that effect. You need to have some kind of proof that you do have a wedding in the works, because they want to be sure of that. The other thing that you have to do is you have to demonstrate that you have met in person at least once during the past 2 years, unless you have some kind of religious or cultural practice that prevents meeting in person before marriage. So in certain cultures and certain religions, that kind of meeting isn't customary. You don't typically meet the person, necessarily before you get married. Sometimes it's an arranged marriage. That's okay, but you do have to provide evidence of that fact. You need to provide statements from family members confirming that it is not customary in your religion or in your culture to meet before the wedding. And in those cases, you can get an exemption or a waiver to the requirement that you have met in person at least once in the preceding 2 years before the petition was filed. All right, so once that I-129 is submitted, it's going to take several months for it to be approved. USCIS, that's the hardest part of any immigration case, is waiting on the government to do its work. So once you get that petition submitted, CIS is going to take several months to send you a decision. If they have all the evidence they need to make a decision, hopefully they will approve your fiancé petition. They will send you that approval. And then the next step step is going to be filing the DS-160 at the consulate or through the National Visa Center. The National Visa Center is going to contact you. They're going to collect a bunch of biographic information. They're going to collect a bunch of documents that they are going to prepare and send to the consulate for that consular interview. Now, your consular interview and all of that documentation will go much faster too if you make sure all of that is complete and correct. So do make sure you pay attention to everything they're asking. They're going to want financial sponsorship information, just like you would be doing if you had already married the person. They're going to want a Form I-134 affidavit of support to demonstrate that you have the ability to support the individual after they come into the United States. And then your fiance is going to have to get a medical exam before this DS-160 appointment. If y'all were already married and you were already filing for the resident process at the consulate, it would be a DS-260 that you would file. This is a DS-160. So this is for the fiance. It's like supposed to be a sort of a temporary status that this person is applying for, because as soon as they get to the US, you're going to get married, you're going to be spouses, and then you're going to move on towards residency. So DS-160 at the consulate, and be prepared to go through that process. Once that process is complete, and ideally that fiance visa is put into the passport of your fiance and they are on their way to the US, then step 3 is that they come to the US and you get married within 90 days of entering the USA. Get married to the petitioner. The petitioner is the US citizen relative who's petitioning for the fiance. The fiance has to marry that petitioner. You cannot come into the United States and then get married to somebody who didn't actually file that petition and expect to get residency that way. That will not work. If the relationship with the I-129F petitioner doesn't work out, then unfortunately you are kind of out of luck and you have to go to your home country. You typically, unless there's some kind of alternative method of getting status through asylum or potentially through VAWA or some other humanitarian program, there's typically no way to get residency unless you are actually marrying the petitioner who filed the I-129F for you. So it's important to pay attention to that and just know that ultimately in this process, it's not allowed to just switch tax, to switch spouses, to switch petitioners after you enter the US. You kind of are limited to that one choice. So hopefully your fiance relationship works out and your wedding is beautiful and you're happy and you're newlyweds and you move on past your wedding to file the I-130 and I-485 adjustment of status packet. We have videos all over our YouTube channel about filing the I-130, filing the I-485, filing them together, and going through the adjustment of status process through a spouse. So please make sure you check those out. After the I-130 and I-485 are filed and you go through the biometrics collection process, then you will get scheduled for step 5, which is your adjustment of status interview. Again, this is a really important moment in the case. This is the moment when the couple presents themselves as a couple to USCIS for an interview about the relationship. This is the first time you will be presenting yourselves as a couple at the same time. Okay, so it's really important to be prepared for this moment. Please check out our video on our YouTube channel about how to prepare with your spouse for your adjustment of status interview. It's possible you could be separated during that interview. It's possible that they could be asking you questions that you don't know the answers to. None of that is a deal breaker as long as you're prepared and you know what to expect and how to handle the situation. So do definitely check out our videos on how to prepare for your adjustment of status interview. That's the next to the last step. The last step is to receive your approval. Ideally, you do great at that adjustment of status interview. You get the resident card in the mail a couple of weeks later. It's going to be important to schedule and calendar time to file your Form I-751. Form I-751 is required for couples who have filed for that. Okay, technical difficulties. I will have to finish this with my camera because my other camera decided to black out. I apologize. Hopefully we can make this work. Okay, we're on the very last step of this process. So the last step, calendar that I-751. You're going to have to file it 1 year and 9 months after the approval of your conditional resident card. You're going to get that resident card initially for 2 years. So you'll need to schedule time to file that I-751 because you're going to have to prove at that time that your marriage is still a good, bona fide, good faith marriage, that you still didn't get involved with this person solely for immigration purposes, only for a green card. You're going to have to show that you are still living together, that you're still a couple, or if you have separated, if you have divorced for any reason, you can get a waiver of that requirement to file jointly. You're going to have to do that around the same time, within 3 months of the expiration of that 2-year card. So make sure you schedule time for that. Now, what you also need to know is that if you are still married to the U.S. citizen petitioner at 2 years and 9 months, or if you did divorce or separate, it's because of abuse or cruelty, then at 2 years and 9 months after you are issued that 2-year card, that's when you can file for your N-400. And you don't have to wait for that I-751 to be approved and finalized before you file that N-400. So all of those additional steps can use a little extra support and analysis with respect to eligibility and how to comply with the requirements. We have lots of videos on our YouTube channel about how to do those. Please check them out. And please reach out to us if you need our support with any individual help that may be required for your case. You can reach us at the information that is scrolling along the bottom. Our website is JLW.law. On there, you can click a button to schedule an appointment with me or with any of the other attorneys in our firm. You can also call us at 512-633-1785. We'll be happy to help you analyze your case, analyze your eligibility. Again, I'm sorry about this weird video thing. I hope this has been helpful and useful regardless of my technical issues. And with that, I am going to sign off. I am Jennifer Walker Gates. Thank you so much for being here. Check out our next video. Let us know if we can help you, and we'll talk to you soon. Bye-bye.